Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm studying professional responsibility and I'll be talking about working with opposing counsel. In this video, I'll be talking about handling evidence, following the court rules, pre-trial and trial obligations, and finally I'll be talking about talking to witness. I would like to go through Rule 3.4 for you. So Rule 3.4 is the fairness to opposing party and counsel. It states that a lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential of evidentiary value. So that was part A of the rule, but I would actually like to go through the whole rule for you. I'd like to show it to you real quick. It's right here. I really didn't highlight it or take many notes in it because I realized that, as you can see, my book is falling apart. So I have to take it easy on this book. So Rule 3.4, fairness to opposing party and counsel, states that a lawyer shall not A, unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not counsel or assist another person to do any such acts. Next, I'm going to go through the part B. Falsify evidence, counsel or assist a witness to testify falsely, or offer an inducement to a witness that is prohibited by law. Part C is knowingly disobey an obligation under the rule of a tribunal except for an open refusal based on an assertion that no valid obligation exists. Part D, in a pre-trial procedure, make a frivolous discovery request or fail to make reasonable, diligent effort to comply with a legally proper discovery request by an opposing party. And Part E, in a trial, allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence. Assert personal knowledge of facts in issue except when testifying as witness, or state a personal opinion as to the justness of a cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of an accused, or request a person other than the client to refrain from voluntarily giving relevant information to another party unless the person is relative or an employee or other agent of a client. And finally, the lawyer reasonably believes that the person's interests will not be adversely affected by refraining from giving such information. So I just went through the rule 3.4 for you, the fairness to the opposing party and counsel. I went through the whole rule for you. Next, I'd actually like to give you a little bit of an example of what I was talking about. So I was talking about proper handling of evidence. This means that no obstructing access and no destroying or altering or concealing or falsifying the evidence. Next, I talked about the tribunal's rules. So a lawyer must follow the tribunal's rules unless making an open challenge, okay? Next, I talked about the trial obligations. So what happens if a certain issue should not come up, the lawyer can't just go ahead and talk about that. So over here I've written trial obligations: no irrelevant facts and no personal assertions or opinions, and to allow others to disclose unless agent and no adverse effect. So these were all the things I talked about in this video. Next, I'd actually like to go ahead and write the bullet points for you. I really hope you enjoy the next part. Lawyer may not knowingly disobey court, no frivolous discovery, no alluding to something irrelevant, no asking people not to disclose relevant information, proper handling of evidence, and must follow court rules. Good luck studying. Bye.